You, get out. Yeah, you.
All right, lawyer.
All right. Good afternoon, everyone. My name is Scott Reich, and this is Crime Talk. Let me see by a show of hands if everybody can hear me. This is more difficult than they think it is. I assure you of that. Anyway, we're going to go with it. I don't see any comments just yet, but I'm going to go with it that everybody can hear me. Well, yes, they can hear me. It's amazing. You know, Frank let me wear his coveted headphones so I could make sure, and I could hear myself perfectly in the microphone. But apparently there was one little itty bitty setting that was not correct. And so we're going to do this all over again, but that's all right. It is always better the second time around. All right. So, like I said, my name is Scott Reich. This is Crime Talk. We usually do our normal show, but Frank, the hardest working man in show business, decided he needed to take the family on a little vacation. So, of course, I had to say yes. I'm like, Frank, then who's going to do the videos? And he kind of looked at me and said, I guess you're going to have to do them. So here I am. But we're just going to do them live without the edit because there's nothing more exciting than live TV. So let's go ahead and open the record for, let's do the intro first. First, did the Kohberger attorneys find what they were looking for? Can you trust the DNA science if the scientist is taking some shortcuts? Should an 80-year-old politician go to prison for corruption? Well, some federal prosecutors in Chicago say yes. A parole officer got killed at his home visit. An 8-year-old boy dies protecting his mom from his dad in a domestic violence situation. And our dumb criminal of the day. Let's talk about it. All right, everybody. It is June 12th, 2024. Let's go ahead and get to the docket today. This is take two. All right. First, the Brian Kohberger matter. As you remember, there's been lots of in-camera hearings as it relates to the Brian Kohberger DNA issues. All right. So the court issued an order in the Kohberger matter and didn't get a whole lot of play anywhere, but I thought it was rather interesting as I was doing my show prep. And the court issued an order and said, hey, based upon that hearing that we had back on May 30th of 2024, the sealed order for disclosure of the IGG information and protection order is amended as follows. And it says the defense counsel, only lists them all, the defendant and the IGG defense experts, Dr. Leah Larkin and Becca Barlow and Stephen Mercer, and the defense investigator may view this IGG material provided by the state, but any further dissemination of this material or the information contained within the material must first be approved by the court after showing by the defense as to why such individual actually needs the information for the preparation by the defense. Additionally, no individuals on the family tree who were not previously known to the defense via the defense's own investigation may be contacted by the defense or any agent of the defense without prior authorization from the court after showing as to why such contact is necessary and material to the preparation of the defense. And the defense mitigation expert who has created her own family tree and who does not have access to any other IGG information, she can continue her mitigation investigation, including contacting the defendant's immediate family members and other related individuals. So, as you may recall, there are issues as it relates to Brian Kohberger, right? The DNA. The DNA is the worst evidence for Brian Kohberger, and it's on, that's right, the little button there on the K-bar, right? What YouTube Crime Talk host has his own K-bar, the alleged murder weapon in the Brian Kohberger matter? Well, this one, because he actually served in the military and had his K-bar that he purchased back in 1988. Can you believe it? 1988. Anyway, DNA is right there. The defense has to be able to explain how that DNA got there. Oh, there comes to be like, well, it's just touch DNA. I don't care. It's DNA. So the defense has to be able to explain that away. And so what they are looking at, they have to say, hey, there's got to be some other mistake. There's got to be some other way that DNA could come back to Brian Kohberger. As you recall, they had this DNA that they recovered. They sent it through the CODIS system. They didn't find any matches of previous people that involved in the criminal justice system. So they created from that this genealogical information, the search that the FBI created. And the defense said, we want a copy of this. And the prosecutor said, no, the defense doesn't get a copy of it because we didn't do it. The FBI did. But the defense or the FBI reported that to the prosecution. So that's really the standard. So the court said, no, FBI, you got to give it to the prosecution. But the prosecution then said, but we didn't even use it, Judge, because we used that to develop probable cause. We arrested Brian Kohberger. Then we got our own DNA sample from him. So we don't even need to use that anymore. But the defense wants to challenge the veracity of that search so that they can say you can't use any of the DNA. It would be obtained illegally because it was basically an illegal search that shouldn't have been done. So this genealogical survey, right, it's created from family members, and they say, hey, Brian Kohberger is related to these people. They have a very similar DNA profile match. So let's look at him as this suspect, right? So the defense gets to look at it. So they get to see if there's something there. Now, what is interesting is the court saying you can't go talk to people that you didn't already know about or maybe even talk to that you learned about in this genealogical information. So basically there could be other people out there that are related to Brian Kohberger and things like that that didn't know it or they could know it. The court says you can't go talk to them unless you do. But they have their own mitigation expert creating this family tree because the mitigation experts do that. They try to figure out, is there something that went wrong with this particular defendant? Is there a history of some sort of mental disease or defect, or was he dropped on his head when he was a kid? You just never know. So they go back and interview everybody as it relates to that. So the question will be, did the defense find what they were looking for? That's the key, ladies and gentlemen. They're dotting every I, crossing every T, and his defense team is good. They're good. They have unlimited resources. And if there's some way they're going to try to make that DNA go away, which I've said from day one, that's his biggest problem, they're the ones that are going to do it. Next, can you trust the science if the scientist is taking shortcuts? All right. We've talked about this case before as it relates to the Colorado Bureau of Investigation and their lead person, Missy Woods. And it's rather interesting because the internal investigation of Missy Woods, basically they've known for years that there was concerns about the quality and the reliability of her work, but they let it go because she was the golden child. So like I said, the agency's interactions allowed Yvonne Missy Woods to continue to allegedly mishandle DNA testing for nearly a decade after colleagues first raised alarms as early back as 2014. And then it wasn't until an intern said, hey, you guys have a problem back in 2023. And then there was another investigation as to everything that she's done for the last 30 years. Now, in an interview during the 2023 investigation, the report describes Miss Woods as the golden child at the agency and a high producer who worked significant amounts of overtime. She was trusted within the CBI's most high-profile cases as well. She was their go-to lady. But colleagues said that she had a reputation among her peers for cutting corners in her work in order to stay as the top producer. Now, the report outlines several incidents over the years that raised doubt about Miss Woods' work, but never led to her permanent removal from the job. When a colleague discovered a problem in Miss Woods' work back in 2014, a supervisor required Woods to fix it, but not to take any additional action. And then in 2018, managers determined that errors in her work were related to some mental health issues that she was going on. Basically, Miss Woods claimed that she was basically overwhelmed by the amount of work that she had been assigned. And so the scientist was temporarily removed from casework. She took some counseling, and she was not allowed to work overtime upon her return. Well, that internal review of her work at that time missed the larger pattern of Miss Woods' data manipulation across cases. Now, the CBI is reviewing its response to the earlier complaints about Miss Woods, like, oh, we should probably look and see why we missed all this because she was a golden child. We were all looking good. So the CBI put out a statement like all government agencies do, and they say, we acknowledge that it took too long to detect ongoing intentional manipulation of our lab system. Intentional manipulation, ladies and gentlemen, that's the key word. The CBI director used himself, and they said, we are in the process of identifying an external vendor to conduct an organizational review to ensure that our forensic service procedures and systems adhere to CBI's high standards. Well, apparently they weren't high enough, right? Because somebody was allowed to manipulate the results. Anyway, the CBI released a redacted version of the report documenting its internal affairs investigation after initially refusing to make the 94-page document public because there's an ongoing criminal investigation into Miss Wood's conduct. Anyway, Miss Woods admitted that she deleted data about low quantities of male DNA in some sexual assault cases, especially cases from Denver police, so that she should have to complete additional testing that was unlikely to produce conclusive results on those small genetic samples. Well, deleting the data likely allowed her to complete cases faster because she didn't have to continue troubleshooting the reports found. She said she did it in sex assault cases because it was easy. According to a partial transcript of the interview that she gave to CBI investigators. She admitted she may have wanted to avoid questions from defense attorneys about, why additional testing on the deleted sample was not done. So Woods told investigators she didn't even think about it, the gravity of her actions at all. I mean, what's the big deal? Until the start of the investigation in 2023. And her thoughts were deleting the data were just click, done, move on, click, done, move on. That's what she was thinking, ladies and gentlemen. Click, done, move on to exculpatory information. Wow, that's great. Anyway, she finally realized and said in the interview, what have I done? She also expected to be caught when concerns were raised back in 2018, but she continued to do the same thing. And then in 2023, investigators began. She worried even more about even possibly going to jail. She has not been charged with any criminal crime yet, so we'll give her the presumption of innocence, but we'll see if charges are going to be filed against her. My guess is not, because then it would blow the whole system up and she'll get a pass like, well, everybody in government usually does. Anyway, Ms. Woods, through her attorney, maintains that she has not offered false testimony in court and her work has not led to any false convictions or imprisonments. While the allegations resulting from the internal investigation point to Ms. Woods deviating from standard protocols and cutting corners in her work, she has long maintained that she never created or falsely reported any inculpatory DNA matches or exclusions. Now, Ms. Woods, after 29 years with the Colorado Bureau investigation, was allowed to retire in lieu of termination late last year after the agency discovered all these problems. And, just the fact that she deleted and manipulated data, she's saying it was basically limited to just sex assault cases, but accounts from her colleagues cast doubt on that claim. For example, in the summer of 2018, a colleague said she caught Miss Woods manipulating DNA results in the case of Alex Ewing, the so-called hammer killer, who has since been convicted of murdering 3 Aurora, Colorado family members, as well as a Jefferson County woman back in 1984. DNA was used to tie him to the crime scene, obviously decades after the killings. That's going to be a problem. Anyway, the colleague said that Miss Woods gave her the case around 2:30 p.m. on a Friday and demanded results by the end of the day. But the colleague found evidence of contamination in the DNA samples in that case, which would have required additional steps to address. Woods then deleted that data to make these samples appear uncontaminated. The colleague told investigators the colleague confronted Miss Woods and refused to sign off on the work. Woods looked at the other colleague at like a deer in the headlight and told Miss Woods that she knew what she did and she can't cut corners. The colleague reported the incidents to the two supervisors, including the CBI Assistant Director of Quality and Forensic Services, and she was so troubled by it that she cried on the drive home from work that day, according to the report. Later, Ms. Woods told a colleague that she had completed the extra work on the case and that she wasn't thinking clearly and was just simply burned out. The supervisor later told the employee that the CBI couldn't prove what happened and that no further action was taken. The colleague also said that the same supervisor had commented a couple of years ago that it was too bad Woods has no integrity because she has plenty of experience. Anyway, CBI since found that Woods cut these corners in much of her DNA testing and then covered up her shortcuts by altering, deleting, or omitting data in her lab work. She also omitted relevant facts from criminal justice records and tampered with DNA testing by omitting some results. This is from the CBI, ladies and gentlemen. The agency has so far identified problems in 654 of Miss Woods' cases between 2008 and 2023, and they haven't yet finished the review of her cases between 1994 and 2008. Now, the CBI this year requested $3 million from the state legislature to retest the 3,000 DNA samples through a third-party lab, and has sought another $4.4 million so that the district attorney's office across the Colorado can deal with all the post-conviction relief claims that are going to shut the system down. Yes, it's the old garbage in, garbage out, or hey, good information in, let's alter the information out so it's really garbage, but we just won't tell anybody. That's right, ladies and gentlemen. That should offend anybody's sense of fairness and fair play. And to say, well, it was only in sex assault cases and it was only minor samples. I mean, a mixture, a third party. Yeah, we wouldn't want that in a sex assault case now, would we? Oh, no, that couldn't be exculpatory. No. Yes. We'll see if Missy Woods gets charged. Now, we'll give her the presumption of innocence, but these are her words in the internal investigation. But I'm thinking Missy Woods, yeah, she needs to be charged. She needs to be charged. Next, should we send a poor, feeble, 80-year-old politician to prison for corruption? Well, federal prosecutors and Crime Talk think so. So federal prosecutors want convicted ex-Chicago alderman Ed Burke to serve over a decade behind bars. They said in their sentencing memorandum that was filed yesterday. The recommended 120-month sentence is the longest serving city councilor in Chicago history, convicted back in December of charges related to racketeering, bribery, and extortion. And that is well within the legal guidelines for Burke's crime, but could possibly condone the 80-year-old man to die in prison. Wow, right? Anyway, prosecutors nevertheless argue that the sentence is appropriate given the weight of Burke's conviction, his formerly prominent position in local and state politicians, what apparently he used to line his own pockets. So, yes, he should go to prison. Anyway, now Mr. Burke has expressed no remorse, apparently, for his crime. He obviously went to trial and was found guilty, and he continues to deny he did a single thing wrong. Mr. Burke's conviction stems from 4 separate episodes. All but one involved his efforts to coerce and convince various property and business owners to hire his law firm called Plater and Burke, now rebranded as KBC Law Group. And part of the conviction relied upon recordings of Burke's conversations secretly captured by ex-city alderman turned FBI informant. That's right. Anyway, Burke is not set for sentencing until later this month, though he hopes to avoid sentencing entirely. He has a pending motion for judgment of acquittal and a new trial based in part on the U.S. Supreme Court reconsideration of the relevant bribery law in the case of Snyder versus the United States out of Indiana. The case questions whether the law criminalizes gratuities, that is, payments an official may have taken in recognition of their past actions or actions they have committed to take, absent any direct quid pro quo exchange. Yes, that case basically says, hey, we can do this. Just don't pay me up front, pay me afterwards, and it'll just be a gratuity. You know how that's the way it works. Anyway, prosecutors even told jurors in the opening statements that he was too sophisticated for that. So anyway, in January, the former Illinois House Speaker, Mike Madigan, won a 6-month reprieve on his own trial of racketeering as the Supreme Court mulls the Snyder case. Anyway, the presiding judge heard arguments on Burke's acquittal motion last week, but has not yet ruled. And the acquittal motion aside, Mr. Burke has also filed his own sentencing memorandum at about 11 p.m. on Monday night. And he urged the judge to forego any jail time, instead advocating for a below-the-guideline sentence, including just give him house arrest. He cites in his memorandum brief, Mr. Burke does, that he characterizes as a fundamentally decent man with no prior criminal history who gave his life to public service, looting the treasury and enriching his friends, which is what politicians do. All right, I added that last part in. He didn't put that in there. Anyway, he states that he is going to have a ton of people that are going to write letters and say that he is a great guy. Now, we'll see what the Supreme Court does. And I get they have narrowed the scope of how politicians can be corrupted, but I don't think saying, hey, I'll do this favor for you and you pay me everything afterwards, hint, hint, wink, wink, nudge, nudge, say no more, say no more. I don't see how that's still not corruption. Politicians should be doing what they should for their constituents and never receive anything other than maybe a thank you. So we'll see if the former alderman is lucky or whether he just simply needs to go to prison. I'm kind of leaning toward prison. Let me know in the comments. All right. I really do believe that, like I said, politicians, there's two kinds. Those that are the corrupt going into the office or get corrupted when they are there in office. I don't think you can really look at either side, but the reality of it is there's very few good people in politics. I'm absolutely convinced of that. And what can you do? Go to prison if you are a corrupt politician, because you can't loot the treasury and enrich their friends. All right. Next on the docket, a parole officer in Maryland goes to do a home visit and never comes back. That's right. Davis Martinez was on a routine residence check back in the last week in May of a convicted sex offender by the name of Emmanuel Sewell. But when Mr. Martinez, the parole officer, didn't report back, fellow officers from the Montgomery County Department of Police were dispatched to Mr. Sewell's apartment in Chevy Chase, Maryland. Officers found the residence secured with the blinds drawn, and after they tried to establish communications with both Mr. Martinez and Mr. Sewell, they forced their way into the apartment. Inside, they found Mr. Martinez wrapped in multiple plastic bags under a bed. That's right, the parole officer. Officers also noted that the body appeared to be in the fetal position and observed a bloody towel near the front door. Now, Mr. Martinez had been stabbed multiple times, including to his head, face, brain, and neck, according to prosecutors. A neighbor told investigators that she heard a loud knocking on Mr. Sewell's door that morning around 9 a.m. And about 2 p.m., the witness claimed to have seen Mr. Sewell walking towards a dumpster before returning to his apartment. Now, soon after, he was allegedly spotted leaving his apartment with 2 clear trash bags full of clothes. He drove away in his Hyundai Elantra, according to the police reports. Anyway, Mr. Sewell was taken into custody the next day in West Virginia. I wonder why he was driving to West Virginia. I mean, I don't know. Consciousness of guilt, perhaps? Anyway, he's been charged. Mr. Sewell has been charged with second-degree murder and ordered held without bond. Now, the convicted sex offender, Mr. Sewell, had been on supervised release since 2021 after serving a decade in prison, actually multiple decades since he was convicted in 1995 for the rape of a physicist. Wow. What can you do? Anyway, Mr. Sewell, allegedly in that case, climbed through a man's unlocked ground level kitchen window and covered him in his bed with his knife, bound his hands and feet, and then sexually assaulted the man. After the assault, he stole the victim's ATM card, video cassette recorder, and his 1991 Plymouth Colt. He then apparently admitted to police that he attacked the person, and Mr. Sewell has yet to enter a plea in this new case. Needless to say, I don't think he'll ever be getting out on parole ever again. All right, take a quick, let me just make sure we're still cruising along here. People still joining us. Hopefully you're all enjoying our show. Like I said, for those who joined us late, we're doing a different little content because Frank's on vacation. So we're doing this. But next on the docket, an 8-year-old boy dies protecting his mom. That's right. A Minnesota boy was fatally shot when he tried to shield his mother during a shooting allegedly perpetrated by the father, who had been released from jail just days earlier after being charged with domestic violence. Amir Harden is the 8-year-old boy, and he died on Sunday at a hospital in Minnesota after suffering a gunshot wound to his head and neck during the shooting last week. Now, a little before midnight on Wednesday, Amir was fatally shot during this domestic incident. 4 other children were also present at the scene during the shooting, and Amir was not apparently the intended target, but the shooting took place during this domestic dispute. Amir's mother, who identified herself as Cherish Edwards, stated on a GoFundMe page that the boy tried wrestling the gun out of the father's hand and that Amir was shot accidentally while the suspect tried to shoot and kill the mother. When Edwards, the mother, screamed for Amir to leave, the child was adamant about protecting the mom. He refused, according to Miss Edwards. "I'm not leaving you here." The suspect, identified as Danier Harden, remains in the hospital, also in critical condition. Danier allegedly attacked Edwards days after being released from that previous domestic violence situation. Now, it's unclear how the father is also in the hospital, but the police are saying, hey, if he's going to survive, we're going to consider charges against him. You think? You go back to the house to intimidate a witness, you commit a burglary, you're armed with a gun, and you shoot your own son, even though mom's saying it's an accident. It's no accident, ladies and gentlemen. Charge the man, send him to prison for a long, long time. And then finally today, our dumb criminal of the day. Yes, a Karen. So apparently after departing her home, our dumb criminal of the day, Sandra Rogers, and of course she was leaving. Where does she live? Peaceful Lane. She argued with the victim over his water usage. That's right. He was apparently washing his motorcycle out on the front lawn. And Sandra became upset about the amount of water the 72-year-old neighbor was using to clean his motorcycle, who was an 80-year-old woman. Miss Rogers was, right? Let me make sure I got, yes, Miss Rogers. Sandra Rogers is our dumb criminal. She is 80 years old. The 72-year-old neighbor who's cleaning his bike, his motorcycle, she gets upset. She spits at the man, yanks on his beard, according to the police report. And anyway, Miss Rogers was in her apartment when she noticed her neighbor cleaning his motorcycle. So according to the complaint, Miss Rogers walked over to the victim and engaged in a verbal argument and regarding his water usage, and used her flip phone to take photos of the wet spots on the roadway so that she could report the victim to the complex management. Anyway, during that squabble, Miss Rogers allegedly spit on the victim, used her right hand and pulled on the victim's beard, according to other witnesses. And they said that Miss Rogers was the primary aggressor. Miss Rogers was arrested and charged with third-degree felony since the victim, that's right, is over 65. That's right. You can't assault an at-risk adult and it not be a felony anymore, ladies and gentlemen. That's a good thing. Anyway, so Miss Rogers got to spend a day in jail before she was freed on a $100 bond because she was concerned about the water usage in Florida. Isn't it raining down there all the time right now? Are you kidding me? They have more water than they know what to do with. I cannot believe it. Anyway, you just can't make this stuff up, ladies and gentlemen. You can't make this stuff up. So I want to thank everyone for joining us today. Understand, Frank, let me have the headphones so I can hear. Second time was a charm. We got it to work. Anyway, thank you very much. Thanks for joining us. We'll see you next time. And remember, yes, the Constitution matters.